see where someone is given a right to traverse over the neighbor's property to get to a public road, okay? Easements appurtenant are characterized by the existence of what's called a dominant estate and a servient estate. So in law, we talk about a dominant land and a servient parcel. The dominant estate, in this is kind of converse to what you might think. The dominant estate is the land that benefits from the easement. The servient estate is the land that's burdened by the easement. So again, if my neighbor uses my land to access the public road and they're traversing over my property is going to be the servient land because I am burdened by their easement. Their land is going to be the dominant estate because they're benefiting from the easement, okay? So those easements are the kind that they run with the land. They can't be severed. They're not sold off separately. They really are for the benefit of that specific property. So they run with that land, both the burdened land and the benefited land. Easements in gross are ones that are conveyed for the benefit of a specific person or a business entity. Those are easements that cannot be sold, assigned, or inherited unless there's a specific language in the easement. And those are going to be your things like utility easements, okay? So let's go to the next slide, and just to give you some common types of easements, those would include right-of-way easements, utility easements, drainage, conservation. Solar easements are big right now because solar energy is one kind of a mandate now, right, that we're supposed to be transitioning over to greener energy. And so there are a lot of solar easements being given. And you say, well, what does that mean? That means that there are easements that are being signed that say that you won't interfere with the solar collection system that someone installs on their property. So for example, you can't plant trees that would impact it or landscaping, and you won't interfere with the sunlight that's needed for the solar collection system. You have, there are more sophisticated easements that get into air rights and things of that nature in high-rise buildings. There are sewer easements. There are, of course, driveway easements. And just so you know, most easements are what we call affirmative. So affirmative easements would allow the easement holder to use the property of another for a specific purpose, right? They're saying, you have the right to do this. However, some easements are actually negative, which means they prohibit a landowner from using his property for certain purposes or in a certain way. And an example of that would be your conservation easement. Let's go to the next slide. Now let's talk about how do we create easements, okay? And there are various ways to create easements. The first thing you need to know is that in most every state, in Maryland included, the law favors express easements, which means something that is recorded as an agreement, as a deed of easement between the parties who are benefiting and burdened by the easement. That is what the law likes to see. However, if there are not express easements, there are other methods of establishing an easement, and we'll go through those. And those would include easements by necessity, easements by prescription, and easements by implication, okay? So we'll talk about an express easement, which is what we would generally see in real estate world and title world, okay? So an express easement is one that, again, is created specifically by the execution of a deed, which generally will set out the location, the dimensions, and the scope of the easement, right? They'll tell us what you can and cannot do with the property, where the easement's located, where you're allowed to travel over the land, and everyone knows whose rights are there and whose rights are affected by the easement. Those easements are almost always recorded, but they can just be there by virtue of what's called an actual notice, meaning you've seen the person driving over the shared driveway for years. You have actual notice that there's an easement, right? Someone has told you, communicated that the easement's been there, it's been in use. So again, we'll go back to what an easement in gross is. An easement in gross means there's no intention to benefit a specific property, right? It's not to benefit my neighbor so that he can get out to the public road. It's not to benefit my neighbor so that he can come onto my back property and use the well, okay? An easement in gross would typically benefit a specific person or business entity. So those are things like your utilities, your poles, wires, cables, sewer, water, railroad lines, sometimes fishing and hunting and timbering licenses, mineral rights, things of that nature. Appurtenant easements are, again, the ones that are intended to benefit a particular piece of land. Those are easements that cannot be severed from the land and sold independently. Again, they're going to run with the land. They're not something that I could, for example, convey or assign to someone else, right? I can only give it if I sell my land. If I sell the land that's subject to an easement appurtenant for, let's say, a right-of-way or a well, I can only give that to the person I sell the land with. It has to go with the land. It can't be something I could give to someone else, okay? I'm going to real quickly just touch on the difference between a license and an easement. We do oftentimes, and some of you may have seen some of these in some of your transactions over the years, we tend to see some of these things more in the rural areas. So we see them specifically in Western Maryland, on the Eastern Shore, some other large tracts of land where there might be something like mineral rights that are severed from the land and are given to someone to come onto the land and take the ore and the coal and the shale and, you know, fracking, all kinds of things, right? So someone can be given a license. A license is just a mere personal privilege that ceases upon the death of the grantor or the grantee. So again, if I say to someone, let's say I say to John Westman, I'm going to allow you, John Westman, to come onto my property and hunt and fish. That is a benefit and a license only to John. John cannot take that and give that to someone else, okay? Because it's only to benefit John. It's not to benefit his adjoining property. It's a personal license, okay? There's something called a profit à prendre, which is French for the ability to basically enter onto someone else's land and remove something of value from the soil or the products of the soil. That would be your hunting, your fishing, your mineral rights, okay? And again, a profit à prendre, similar to an easement, can be either appurtenant or in gross. So where, for example, someone is given a profit à prendre to come on and take the minerals or game, right? They can come on and hunt all the geese they want, or the pheasants or the deer. You know, that can be something that can be treated almost like a quasi easement as a profit à prendre, meaning you could convey that alone to someone else, or it could be something that is only attached to your ownership of the adjacent land. And once you give away the land, you no longer have the right to come onto my land and do any of those activities. So that's just something to keep in the back of your mind. If you ever get one of those fluky, you know, ones where you do have a hunting or fishing or timbering or, you know, mineral rights, okay? So we also can get what's called an implied easement. So an implied easement is an easement that would be effective without being recorded in the land records. That's something that, again, we look to see if we can get an implied easement if we see that perhaps a property is landlocked, or we see that a property doesn't have a recorded right-of-way to the nearest public road, okay? And that's something we see on the back end sometimes if it's in the chain of title, or if a survey would bring that to our attention. And oftentimes these other types of easements, other than the express easements, which are recorded as actual deeds, identifying a specific grantor, a grantee, and assignability and words of inheritance that say it's going to run with the land. These implied easements, easements by prescription and easements by necessity, many times end up in court, okay? Even the express ones that are recorded in land records oftentimes end up in court. And we'll go through just a few cases that I'll tell you about that are interesting and how the courts in Maryland have ruled on these issues. So implied easements would require that both the burdened and the benefited parcels at one time were held in common ownership. Okay, so that would be, for example, I owned 60 acres and I decide I'm going to carve out 6 lots, 10 acres each. And, you know, I do not give a right of way for one of those parcels that then becomes landlocked. Well, then there would be an implied easement because I was the common owner of all those lands, that land is intended, implied to have an easement to get to the public road over the other lots, okay? So that would be, again, the presumption is that a conveyance of land that calls to a road or right-of-way creates an implied easement to use the road, okay? A conveyance of a lot on a plat that binds on a road creates an easement by implication to use the road on the plat to the nearest public road, okay? So, Brian, an easement by implication, again, typically involves the conveyance of a landlocked parcel of land. It can also involve a conveyance by a grantor, which leaves the land he retains landlocked. So let's say, for example, I'm giving away 5 of those 6 10-acre lots, and I realize, oops, mine's landlocked now. I've created a block for myself. Well, there's an implied easement that it's necessary. It's an absolute necessity for me to use and enjoy my property to have that easement. And I could, again, prove that I have a right to that implied easement, okay? We also get then, next screen, prescriptive easements. Prescriptive easements are really sticky. Prescriptive easements are exactly what they sound like. It's kind of like, I'm sure you all have heard of adverse possession, right? Which is where you prove that maybe you get title to the land because you've used it in an open, hostile way for 20 consecutive years. A prescriptive easement kind of works in the same way. These don't need to be recorded. They most often are definitely not, because if they're recorded, they automatically mean people are aware of them and it can't be hostile, right? Because it's permissive. If they're recorded, it's permissive. I'm, as the grantor, saying I'm giving you the permission via this recorded instrument to use my land or to have this specific easement. For a prescriptive easement, that can't be. It has to be something that arises by operation of law. It has to, again, be adverse, exclusive, and uninterrupted use of another's property for 20 years. So again, let's say I've been using an old farm road and I've done it consecutively for 20 years. And let's say there was never a recorded right-of-way or easement for me to use that farm road. I might get a prescriptive easement by proving these elements, okay? But however, from a title perspective and from a sales perspective, a prescriptive easement, if that's the only way to access the parcel, it's typically not insurable title unless there's a court order saying you definitively have the right to use this easement, okay? And again, because it's hostile and adverse, if it started out as a permissive use, it can't then turn into a prescriptive easement. And there actually have been cases about this exact issue. Next is a necessity easement. So a necessity easement, again, is very similar to implied. It's, again, effective without recording it. And you typically see it, again, in these landlocked situations where basically under Maryland law, you have to show that I have to have a means of ingress and egress to my property in order to use the fair enjoyment of the property, okay? It's a public policy doctrine that says we all want people to have full utilization of land. And the intent of the parties is not to render the land unfit for occupancy, and landlocked land would not be fit for occupancy, right? No one wants to have to parachute into their land. And just again, to sum up, the prerequisites to the creation of an easement by necessity are that you have to have an initial unity, meaning that landlocked parcel had to come out from a common grantor so that you can show there was, you know, an access to it from that original grantor that should have continued throughout the chain of title, but for some reason did not, and that it is necessary. So how do we get rid of easements? So what we have to see from a legal standpoint is we have to see an actual termination or abandonment of an easement, which would really almost always require a recorded document. So the law in Maryland says that non-use alone is never sufficient to terminate or abandon an easement, which is interesting, right? Because you would think that if we all just stop using it, that would be proof that we've decided to abandon or terminate the easement. But in fact, the courts in Maryland have said no, non-use alone is not sufficient. It requires unequivocal acts by the easement owners. And also all owners and mortgagees have to join in, right? And that includes anyone with an interest. So what's interesting here is, and I'm sure most of you have had the situation where lenders require a road maintenance agreement, right? I mean, how many of you have had that? I suspect the majority of you have seen where there's been a private road that the original family members who all owned the lots were using happily with one another. The properties then sell, and ultimately someone comes into title who decides they don't want to share the road. They're going to block the road. Well, I have seen it. I have seen cases where, you know, an agent called me right after settlement and the buyer was very distressed because the remaining family members, who were very angry that the first lot had been sold to a non-family member, decided to erect Jersey walls all along the private roadway so that the person had to actually park and get out and walk to their home. And that ultimately ended up in court, that case, because these people dug in their heels and thought they had a right to block the access. Well, they didn't. So that is one reason why lenders really want a shared driveway easement recorded and a road maintenance agreement. So they're two different things. They tend to be recorded simultaneously, but sometimes you won't have a road maintenance agreement, but you will have an easement, okay? And if the easement is there, that's really the important thing, and I'll touch on that later. But the main reason lenders are requiring these recorded right-of-ways and recorded road maintenance agreements, they're not to benefit your buyer. They're to benefit the lender, because the lender wants to know, if we have to foreclose on that home, will we have access? Will we be able to resell that property if we have to buy it back in a foreclosure and have access to a public road, right? That's what lenders are concerned about. They want to protect their own interest. And we have actually seen cases where when the lenders don't join in the creation of a road, a shared roadway easement, if the lender forecloses on a deed of trust, that easement is no longer effective as to that parcel. And that's when you get into some really sticky situations. So that's why it's important. That's also why it is nearly impossible to get a truly valid shared driveway maintenance agreement or easement, because we would have to get every owner and every lien holder, meaning every mortgage lien holder on those parcels, to join in that document in order for it to be really as 100% suit proof as possible, okay? So next we'll talk about utility easements. So utility easements are common, right? We see those all the time. Those are for your gas, electric, sewer, and they're usually for the purpose of installing and maintaining utility lines and structures. You know, there are storm drainage easements that are permanent and run with the land. We see those frequently. They're oftentimes shown on location surveys. And those do place some affirmative duties on the lot owners to maintain those storm drainage easements that are on their property. They'll usually require the owner, right, to give up certain rights, like they can't build permanent structures, any kind of decks, additions, certain types of fences, you know, stone walls can't be built within those storm drain easements because they need to be free for the flow of water. They'll also have obligations sometimes for them to be, you know, maintained in a certain way and inspected annually by the county. Conservation easements. I'm sure some of you have sold properties that are subject to conservation easements. So conservation easements are voluntary deed agreements that protect conservation features of a property. So it may be that you get one that's in a perpetual agricultural or scenic view or other natural resource conservation easement. There are easements given to the Maryland Historic Trust, to Department of Agriculture, to DNR. Those easements, right, would prohibit intensive land uses like commercial, industrial, and high density residential development. So the benefit is to have those properties placed in a perpetual conservation easement that would prevent the land from subsequently being developed. We do see large tracts of land in Howard County, Carroll County, placed into these conservation easements. And again, there are tax benefits to that. Those easements, actually, the county and the state and the trust pay, like the conservancy, the Nature Conservancy will come in and buy a conservation easement, and they actually pay the homeowners, right? They pay the landowners for that easement. So they do get something out of it. They also get tax benefits, but they will be in perpetuity, and they will prohibit certainly many uses of the property for all future owners, okay? So again, they retain, the rights of ownership, privacy, and uses within the terms of the easement. It runs again in perpetuity, and you always want to make sure as an agent that if there's a conservation easement, one, it's required disclosure under the MAR contract, right? A true conservation easement must be disclosed by the seller in the sales contract, and you want to provide copies of all of those to the buyer, and that is a real buyer. Read that and talk to your own attorney to see what it binds you to do. Easements can last be created by plat. So if there's a plat that's recorded that shows an easement, that is now, since our Court of Special Appeals ruled in a homeowners association case back in 2011, ruled that an easement on a plat is effective to create that right, okay? It does create an easement. It doesn't mean that you have to actually record a separate recorded deed agreement to create the easement. It can be created by being on the plat. In this case, what happened is an HOA recorded, this I think was Harford County, the Emerald Hills Homeowners Association had a plat that was recorded that gave a little triangular piece of property as an access easement for the benefit of an adjacent property that was actually not part of the Emerald Hills Homeowners Association. Well, the owner of the adjacent parcel decided that they wanted to build part of their driveway onto that triangular easement. The HOA sued. Ultimately, this case ended up costing the homeowner $50,000 to litigate. He won, but we were ultimately talking about 2 feet worth of driveway that was on the easement. And the court ruled that that plat did create an express easement over the triangular parcel in the HOA property for the benefit of an adjacent property that was not part of the HOA. And the next screen just is an actual picture of this property. And, again, you can see they erected their signs about private driveway, no through traffic, but $50,000 to basically get 2 feet worth of driveway is a long fight to go, I think. So let's again just touch on the shared driveway easement versus the maintenance agreement. So when we have an actual shared driveway easement, that's great. That's what we're looking for. We need to know, does the right exist for the parcel to traverse over the adjacent parcel to get to the public road? If we see that, that's good. That's what we need. Lenders are concerned with, who's going to maintain it? We always, quite frankly, as title attorneys, find that odd, because there's law in Maryland that says that each owner of a joint right-of-way has to maintain it in an equitable proportion based on the extent of usage. So let's just, for example, I live on a private road in Ellicott City. I'm one of the last houses out of the 6 houses on the road. We pay more for the maintenance of the roadway because we use more of the roadway. So that proportionate usage is speaking to, if you're the first house, you're only using, 10% of the driveway. If I'm the last house, I'm using 100%. So for things like snow removal, maintenance, repairs, repaving, unfortunately, if you're the last house on the lane, you're going to get a bigger proportion of the bill. And that's what the law case law in Maryland says. So again, there was a case back in '92 where the court said the cost of maintenance will be distributed among all users in proportions that closely approximate their usage. And what happened in that case is the owners of the servient estate, the estate that had the entire driveway on it, didn't want to pay any of the expenses as to the maintenance of the easement. And the court said, no, it's going to be shared, however, in proportionate to each owner's use of the land. And that's important. And again, it's important why we need all parties with an interest to join in those documents. So let me just do a quick case study, and then we'll jump into the covenants, conditions, and restrictions issues that come up. So this is a case where, I don't know if many of you know Dobbins Island out in Anne Arundel County. It's kind of a famous destination for boaters. It also was the subject of last couple of years of a massive suit with DNR because they overbuilt, the island was sold and they overbuilt what they were allowed to do and took down trees, and DNR sued them, and the owners ultimately had to tear down part of the house. So it's been a very interesting and storied history of Dobbins Island. It actually has a lot of buried treasure stories attached to it, so it's kind of folkloric. But in this case, what happened is, over an easement, the Magathie River Association sued the new buyers of Dobbins Island, seeking to establish a public right of way to use the beach located along the island's northern crest area. Because for years, if any of you have ever been out in that part of the Magathie, you'll know boats tied up on that island every single weekend, every single day, and people would sunbathe, relax, picnic, go on to that private beach there, okay? So in the trial court, next screen, the judge held that the plaintiffs, meaning the Magathie Beach Association and the public, had found and proved they had an easement by prescription to use that beach. So the new owners were going to be subject to people coming on to their private island and using that portion of the beach, from the high water mark to the vegetation line, to swim, sunbathe, kayak, picnic, do whatever they wanted, right? And the defendants, the new owners of the property, had erected big fencing and cables to block everyone, and the trial court said, take all that down. You're going to have to allow these folks in. Well, of course, the new owners, being livid, appealed to our Court of Appeals, and the Court of Appeals determined that no, in fact, there was no prescriptive easement, meaning the association really didn't prove that they had had a hostile and adverse use of that beach land for the 20-year or more period. They said that it was permissive use because it was natural, undeveloped, and untouched beach and woods that could not be adverse, that it was permissive in their eyes. So that's interesting when the court kind of does a flip-flop, but it just goes to show you the courts do not like prescriptive easements, okay? They don't like them. They want to say, well, in this case, normally what we do is we make you, who are trying to make us determine that there is an easement in your favor under prescription, we make you show us all the elements of adverse, hostile, continuous 20-year. However, in this case, we believe that the presumption is it's permissive, and then they lost. So again, they were, forced to, nobody can use that beach now, and it's not public. But in another case, this Purnell v. Beard and Bone, which came out of Worcester County, the right-of-way court said, yes, you are allowed to use that to access your landlocked property, even though that right-of-way had not been used for more than 90 years. So again, that goes back to non-use alone is not sufficient to extinguish an easement. So in that case, there had been a common owner of all this land. They deeded out 3 parcels. The one remaining parcel would have been landlocked, but that parcel, which was being used for timbering and hunting and as a nursery over the course of 90 years, had been using an alternate roadway to get to it. It had an alternate roadway in the back, not that existing right-of-way from 1918. The court said, it doesn't matter. We're still going to allow them to use the right of way from 1918, even though they didn't use it for the last 90 years. So again, I think these decisions are all over the place. Here's one that happened in Frederick County about a well. And we have had well easements that have popped up. So in this case, there had been a well located on adjacent land that the homeowner had been using for a period of 30 years. The properties then sold. When the properties sold, the new owners said, you can't come on the property, which happened to be a church, said, you can't come on the property to use the well. We are now withdrawing our permission for you to use the well. Ultimately, the homeowner who was using the well took it to court and lost because they said the use was permissive. When it was pulled back, it stopped being a right that you could use the well. So again, these easements go all over the place with the court. So nobody can think they're going to win just because they can prove it's been used in a certain way over time. And, you know, we're going to talk about the covenants, conditions, and restrictions, but I want to touch on, and I think, Amy, are you on here?
I am finally on.
She's on. Okay. Okay. So I just want to touch on a well issue. So again, one of the things, and we're going to address this when we get into the easements, is that a lot of these easements that are recorded in land records were recorded many years ago. So again, this one that I just touched on, where there was an old right-of-way from 1918 deed, these easements are there, but we might not see them in a current title search because we're only required to search 60 years back for a good insurable title search. We only have to go back 60 years. So let's say an easement was actually recorded more than 60 years ago. We might not see it. We might not know about it. What does that mean in practical terms? What that means is your buyers could be being burdened by an easement that they're not even aware of. We're not aware of. So we had this case happen, and I think Amy knows this case well, where when I say well, it is well, there was a well involved. So back in 1920, a well easement had been granted from Lot A to Lot B, so that Lot B could come onto their property and use this well. Well, lo and behold, years and years later in 2016, the property sold. And when it sold, the new owner of the property on which the well was sited, okay, which is the servient property, the burden property, that owner buys the house. We see nothing in the title search about this well easement, goes to settlement, happens to be an attorney. He's in his new home, looking out his window, and he sees this old farmer trotting down from a neighboring property to come use the well. And he blows a gasket and says, what is going on here? I don't want anyone using this well. First of all, I have livestock on the property that could contaminate the well. I don't want to be liable for someone being felled by parasites or bacteria in the well because it's livestock on the property. He files a title insurance claim. And ultimately, we look at the title policy and we realize that easement is not taken exception to because it was outside the 60-year search. Being outside the 60-year search and not being listed as a specific exception, the title insurer had to step in and fix that problem. And I think, Amy, do you remember that case?
I do remember. And it was something that we had no knowledge. No one had any way of knowing. So the only way it came up was when there was the neighbor that came forward to use the well. I think it was an old spring that you get sometimes on old farm property.
Yeah, it was an old spring, but that was his source of potable water though. And I think that ultimately what happened is they had to step in and put in a new potable water source for the benefited parcel. So, you know, these are strange things that can happen, but again, real life is always stranger than fiction. So let's talk about the covenants, conditions, and restrictions. So again, just a primer on what they are. They're a set of rules that govern the use of a certain piece of real estate, right? So a covenant, condition, or restriction can regulate the style and size of the homes that can be built in a community or a development. They can regulate types of fences. They can regulate everything from garbage cans to the type of animals and the number of animals that can be kept on the property. They can mandate what type of landscaping. They often contain architectural controls, right? Which will allow sometimes even just one person, the developer, to be the one to determine what is acceptable and what is not, right? And that's not necessarily purely objective, right? When one person gets the right to determine what is tasteful, for lack of a better term, and what is not. So we most commonly think of conditions, covenants, and restrictions in planned communities, right? Or common interest developments like condominiums, industrial parks, and they're recorded in land records, and they definitely run with the land, meaning they are binding on everyone who buys within the development that's burdened by the CCR. So again, a restrictive covenant in property law is a limitation on how you can use your property. Now that might seem unfair if you own a lot of the land that you can't decide what to do with your property, but restrictive covenants run with the land, and anyone who buys or uses them are bound by the recorded restriction, okay? They can be created by way of a deed. So it might be that it's just in a deed back in the chain of title that says this is what can and cannot be done with the property. Or more commonly, what we're used to seeing is recorded separate declarations, right? Where the developer or the association records a declaration that says, this is what's binding on everyone. And sometimes those declarations are amended. Sometimes they're amended to add additional parcels. We have actually had a case in Howard County where it was a higher end community, and for some reason they failed to include 2 of the lots in the legal description. And it became a real fight as to whether those 2 lots were going to be bound by that declaration because of a simple typographical omission. And, you know, again, those are the kind of things that end up in court. But there's a real difference between what you all have to disclose and what your obligation is under the Maryland Homeowners Association or Condominium Act and a covenant, condition, or restriction that is recorded, because again, these are enforceable by homeowners association, neighborhood associations, which are not necessarily homeowners associations, a builder, developer, or any lot owner who's bound by the CP. Now, I don't know, you know, I have an example that I think John or Joe, you can send that example around, but this was just a sample where someone called me and said, I'm so upset because you all sent a copy of covenants, conditions, and restrictions to my buyer, and he did not want to buy in an HOA, and I didn't know it was an HOA. And we said, well, it's not an HOA. There is no homeowners association, but there are recorded CCRs. And they significantly, in this case, affected a specific use that this buyer wanted, right? If your buyer says to you, I'm buying in here because I hate homeowners associations. My last homeowners association was dreadful. They came out and did annual inspections. They made me repaint things. They made me take down my fence. They wouldn't let me keep my beekeeping activities. I mean, I hear all kinds of things that people are irate about, and they want to live without those restrictions. So they put in a contract for a home, and you know, not all title companies do this, and we are not under any obligation to do this. We try to send people copies of recorded covenants, conditions, and restrictions, okay? Not the HOA ones, because that's disclosed in a separate addendum in the contract, but ones that are recorded as a separate declaration in a community that is not technically a homeowners association. And the real distinction between a homeowners association, mandatory disclosure is, are they allowed to levy a fee or impose a fine, okay, associated with an assessment. And homeowners associations are empowered to do that, okay? But that doesn't mean it doesn't have CCRs somewhere in the chain of title or a separate document. And in this case, what proved to be pivotal was, again, the buyer ended up getting out of the contract but losing his deposit, because it was not a breach by the seller for failing to disclose a homeowners association. It was simply that the buyer did not like the covenants, conditions, and restrictions that he would have been bound by. And again, in the sample one that I gave as an attachment, and you all can, when you get a chance, you can look through it if you want to, just to see what a sample one looks like. It's again says that it renews automatically every 10 years after the initial 20-year period for another successive 10-year period, unless 90% of the owners and lien holders move to terminate the declaration. Well, that's not going to happen, right? Nobody's going to be able to get 90% plus every mortgage holder on the property to join in to terminate. So these things are out there, and they do rear their ugly heads. You know, we have had people, and we've had even agents who have been brought into suits because of conditions, covenants, and restrictions that impact the buyer's use of the property. Now, we'll talk a little bit more about that, because what really is your duty. But I think first and foremost, what you always have to remember, and I'm sure some of you have had this unpleasant experience, is there is nothing that will prevent someone from suing you, right? Everyone has the right to bring a suit. Whether they're going to prevail on the merits, that's a different story. But the bottom line is, the minute you are named as a defendant in a suit, you can guarantee you're going to pay your entire deductible on your E&O insurance, just to even prove that you have no liability whatsoever and you did nothing wrong. And it's a really awful position to be in, okay? So first thing is that, let me just touch on this. In certain covenants and restrictions that are based on race, religion, or national origin, obviously federal law prohibits those. Those are not enforceable. So we know that there's a law now that was passed a year and a half ago that says that any of those restrictions that are in recorded declarations or covenants, and there are many of them. If you ever read some of the old ones, and Amy can attest to this, they're rather offensive. I mean, they really are. No matter what your political position, some of them are very offensive in their terminology and who they will not allow to live on the property, based on race, religion, or national origin. They're really disparaging. So we have a law now that says that an HOA or nonprofit or anyone who's a governing body can go in and amend a declaration without going through that big formal 90% or majority of the members signing off to delete any of those prohibited restrictions. The other thing is that, and this touches on the next screen, a law went into place that allows people to basically, to help with that 60-year search issue, to re-record a notice saying there is an old easement and an old covenant restriction or condition that's outside the 60-year search. So what they can do is, if I know that I am the holder of an easement to use a well that was recorded back in 1920, I can record a new document, which is kind of a placeholder, just a notice in the current 2021 land records that says, hey folks, be on notice, there's an easement back from 1920 that affects this property. I have yet to see one come up in any kind of search where someone has done this, but again, this is a fairly new statute, and it would allow them to do that. It would be great if that was a requirement, but it's not. And again, the fact that they don't file anything new doesn't affect the validity of the existing easement. Again, it could have been recorded in the early 1800s and still be binding, okay? So the last one that's just a statute change is about condominium associations. I won't get into the whole statute, but in a nutshell, what it says is this. Sometimes the condominium developers and vendors were putting in their declarations that the condominium owners couldn't sue them for certain defects in the building of the condominiums. Well, there are a legion of condominium lawsuits going on by condominium unit regimes where they're suing the builders for bad material that was used, and now they have special assessments that go on and on and on to cure some of these building defects. So this is basically, this law was to get at, listen, developers and condo builders, if you're going to put a restriction in there that says that the unit owners cannot sue you for something to do with your failure to comply with the building code, you can't do that, right? And you can't shorten their statute of limitations, meaning their time limit to bring a suit against you. I mean, that's really pretty egregious that they were trying to do that by putting it in the, and then, we'll talk about, again, big things to know is that in your contracts, there are definitely already provisions in there that tell a buyer, beware, right? It's a buyer beware when it comes to covenants, conditions, and restrictions. And that is, unfortunately, the Wild West. because it is specifically a buyer beware. My advice to you would be simply, if a buyer says to you, are there any restrictions on the use of this property? Or if a buyer says to you, I'm buying this property because I do not want a homeowners association, I do not want anyone to tell me how to use my property, I want to have horses. Someone tells you, I want to have a stockade fence, I have large dogs. Someone tells you, I want to keep an apiary for honey and bees. Do not give them advice. Just say to them, you will want to familiarize yourself with any restrictions that might be of public record, that might be in the chain of title, that might be in the zoning laws. So again, paragraph 21, and I'm sure you all are familiar with this, but I've highlighted the one sentence that I point everyone to. And it says, buyer expressly assumes the risk that restrictive covenants, zoning laws, or other recorded documents may restrict or prohibit the use of the property for the purposes intended by the buyer. So again, it pushes it onto the buyer, right? It is a buyer beware. If you have a specific use that you're contemplating for the property, it's up to you to determine whether that can be done on the property. And do not give advice, because I have seen many people brought into suits, or even, and I have a case that was actually brought up in front of the commission, and those, they come up there as well. Next is paragraph 54, just a sub-paragraph in 54 again, speaks to existing zoning or permitted use of the property, including whether the improvements were done with permits. Okay, all of that, again, go check it out with the county or the state. The general addendum to the contract of sale that's for use with the Maryland Association of Realtors contract of sale says, paragraph 2, again in highlights, restrictive covenants, the particular use may be limited. So again, there are many places that if you use even just the standard paragraph 21, or if you get into one of these addendums, okay, and I know there's also a separate addendum that specifically just says the CCRs, but paragraph 2 in the general addendum, paragraph 8, the next slide in the general addendum, again, I've highlighted. Many properties are also subject to covenants, even though the property is not subject to a homeowners association or condominium association. You're encouraged to inquire as to whether those. So again, it is replete in the contract and in the addendum that it is a buyer beware. Again, 9, the next slide, would talk about private agreements, about, again, there might be a private agreement that has something to do with that. Again, not within the purview of an HOA or condominium law that could be recorded. So, you know, we do have shared water systems in some areas. We do have shared community wells in some areas. Those are things, it's not technically a homeowners association, but that is a recorded agreement that again would affect your use of the property or the use of someone else's property. So these are all things that you need to be aware of. But I think the key takeaway is that you're under an absolute duty as a licensee to ensure that a true homeowners association or condominium association is disclosed, and to provide all of the documentation, including the declaration and bylaws, to a buyer, right? If you're representing the seller, and the seller's obligated to do it, but of course you're the conduit. So that is distinct from the CCRs, okay? There may be these CCRs, and if in fact the property is not part of an HOA, it becomes a little murky. And this is where I think people get into trouble, because you all are in a helping profession and our nature is to want to help people. So when people ask you these questions, try not to answer them. I know you don't want to alienate your clients, but you also want to insulate yourself from any sort of lawsuit. So let's talk about this little issue. When could a covenant conditional restriction become a material fact that once it comes into your purview of knowledge, you have to disclose that, because you know it would affect a party's decision to buy or sell the property, right? So I had an agent who was selling a property. Again, this was one of those higher end properties in Howard County. And the property at that point, it was not specifically included in the HOA declaration. However, the seller had received a notice from an attorney saying, we are going to bring suit to bring your property into the HOA. We're going to assess all these back dues. What we're willing to do is waive all the back dues if you will voluntarily sign a waiver to join in the HOA. So at that point, there's actual knowledge, right? That there's something going on with this property that is potentially in part of an HOA, that has potentially got these restrictions on it. At that point, it absolutely is a material fact, right? I mean, you have knowledge of it as the listing agent. You need to do something about it. There also was a case where, you know, I've had one in Southern Maryland where if the agent then finds out because this one buyer backs out based on the CCRs, and now the agent is aware of these CCRs. At that point, do you think that that agent now has a duty to disclose those existence of the CCRs to another buyer? Anybody? I mean,
Yes.
that
Yeah, I'll say yes.
Yes, they do. Yeah.
yeah, I think so too. I think once you have, again, because your duty, you know, again, this is where it gets to be a really sticky wicket. The seller may not have that duty, right? Because the seller, your duty of care is higher than the seller's in many instances, right? Because you have to disclose a material fact that might affect a party's decision to buy or sell the property. The seller has to comply with what is the legal obligation on the seller. Well, legal obligation on the seller is not to have to disclose every CCR. They have to disclose a homeowners association and provide the declaration there.
Right.
So again, it would be, and the reason for that is it's really kind of against public policy. It would be very difficult for a seller to know what particular use a buyer has in mind, right? I mean, we don't know that the buyer intends on putting, you know, having beekeeping on their back property. We don't know that they want to have farm to table gardening in their backyard. We don't know that their lifelong desire has been to have 2 horses. You know, all of these things, right? I can't contemplate necessarily as a seller what you as a buyer intend to do with the property. You know, maybe you wanted to put an in-law suite on, and maybe there's a prohibition in the architectural guidelines in a non-HOA property that you can't have an in-law suite, right? So that would be kind of an undue burden on sellers. But unfortunately, again, once it becomes part of your knowledge, that's when you get into, do I need to disclose or not?
I think, Raina, going back to the first example you gave of the potential of the lawsuit to include the house that wasn't in the HOA to be included in the HOA, did the seller actually tell the agent this, or did the seller, did the attorney's letter not surface? How did that work?
Yeah. So what happened was, and again, in that specific case, the seller did not disclose a homeowners association on the contract of sale. And then this letter showed up, and the seller told in this specific case, the seller told the list agent about the letter, but specifically said, I don't want you to say anything. Now that's a real bind. Right? Because no matter if the seller tells you don't say anything, your duty is you have to, right? I mean, you have a fiduciary duty.
It satisfies knew or should have known, and they actually found out, right?
Yes,
Okay.
yes. So that one was a real doozy, and got lots of people involved because again, they went back to, and the property had been sold before, and in prior listings it had not been disclosed it was an HOA. So there was, the seller was saying, look, it's never been sold as an HOA. So, you get into those kind of issues. There was a case, and I've attached this, and if you afterwards want to send around the PowerPoint and attachments, John or Joe, please do. This is a case from the NAR website that I've used for other purposes when I'm talking about an agent's duty to disclose material facts. And it's a case that came out of Harford County, and it's got 2 issues in it. One was that the agent was brought up on, there were charges at the commission that I'm sure you all are familiar with this area in Harford County where there was a contamination of all of the groundwater by the Exxon gas tanks. It's an area up there that's well known that there was a groundwater pollution. It's so bad that 20 years later, everyone in that area is still using bottled Deer Park water that ExxonMobil has trucked into every home
Wow.
for drinking
Yeah,
purposes.
Ray, that's
Okay.
over in Jacksonville.
Is that where that is?
Yep.
Okay.
And,
Yeah, so
and-
this agent though was they're twofold. So one of them was the failure to disclose that issue about the possible contamination, okay? And in that part of the proceedings, they found that she did have a duty to disclose it because she lived in the area and therefore should have been aware of the issue. This agent lived very close to these properties and should have known. But the bigger issue was an HOA/CCR disclosure issue, okay? And in this case, and it's a really easy little 3-page thing for you to read, but it's very illustrative of what can go wrong, okay, for an agent. So in this case, when she was reported to the board for failing to disclose a homeowners association, it was because the buyers had specifically retained her and told her they wanted to build a big fence on the property for their dogs. Okay, so, and believe it or not, this fence issue with dogs has come up at least 5 times where agents have called me with legal suits kind of stemming from this exact issue. Okay, so in this case, they retained this licensee to help them purchase a home, and one of their crucial things was they wanted to build a fence for their big dogs. Well, there was no HOA disclosure in the listing. There was no HOA addendum in the contract of sale. Goes to settlement. They go to build this fence and they're told, no, there are CCRs that restrict you. You cannot put in the fence. Okay. So they're livid. So they again bring this suit, and the agent goes up in front of the commission and they say, you know, why didn't you disclose the HOA? Okay. And ultimately what happened is it turned out there was not an actual homeowners association. So technically the licensee didn't do anything wrong. Again, but it went up on appeal. The original sentencing did find her at libel, and they did place a $4,000 fine against this agent. But on appeal, they found out that no, it technically was not a true HOA. It was a voluntary association, but had conditions, covenants, and restrictions that, yes, did prohibit the fence, but technically the licensee didn't do anything wrong because the obligation on the licensee was to disclose a homeowners association. And in fact, this was not truly a homeowners association. So that's an interesting case because it really pivoted on whether there was an HOA or not, right? Not the CCRs. Now,
Raina, Shirley
Yeah.
had a question real quick.
okay.
So, and I put it in the chat also, so I didn't know if you saw that.
No,
Okay. Can you see that, or should I repeat it?
just repeat it.
Okay. So what can buyers or buyer agents do to find out if there are CCRs on a given particular property?
So the first thing I would say is this. I would never, as a licensee, undertake to determine whether there are CCRs, right? That's just putting you at too big of a risk because again, they could be out there and they could be outside our search period. Title companies will oftentimes see them. What's sometimes crucial is to get a copy of the commitment for title insurance to the buyer so that the buyer has the opportunity to look at it and see, you know, is there something that says, oh, there's an exception listed to a deed recorded in LIBOR, blah, 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 folio, blah, blah, blah. Well, maybe in that deed, it says nobody can have more than, a common thing is nobody can have keeping of any livestock on the property. Well, nowadays, everyone wants chickens. Everyone wants fresh eggs. Everyone wants chickens on their property. Is that livestock? So, you know, if someone, my advice is, it is difficult to ascertain if there are CCRs. If they're in the 60-year search period, okay, maybe they're going to show up. They should show up, right, in a search. If they're outside the 60-year period, it's fair game. Who knows what's out there? So never undertake that obligation. And if a client asks you specifically, I'm buying this property because I want chickens. I want free range chickens. If they're telling you they want it because they want a large fence, if they're telling you they want it because of whatever, okay, that they have an RV That's another common one. They have an RV that they want to store on the property. They have a trailer they want to store on the property. Those are oftentimes limited in CCRs. They don't, the declaration says no keeping of an RV. Driveways have to be paved. There's architectural controls. So it is just a dangerous landmine for you all to walk into if you undertake to say, I'm going to determine whether there are CCRs for you. Just, you unfortunately have to kindly, gently put it to the buyer beware, go talk to the county, go talk to zoning, find out what's permitted on the property, call the title company, ask them if they saw anything in the, again, if there's someone that brings up a specific issue to you. I wouldn't say you want to do that on every transaction, because frankly, it would be a burden on most title companies to have to answer every, buyer if there are CCRs, or to contemplate what their, what their intended use is. And I'm sorry.
Raina,
Yeah.
well, I was just going to say, for me, especially in a county that we see a lot of the CCRs, in a more rural county that aren't tied to an association, I've had a lot of problems with them coming up and the buyers not being aware of it. And I think the whole issue of, they thought it would have been disclosed to them by a seller and it wasn't, and no one really seemed to understand whose responsibility it was to find out. But I think some of it is a timing issue. If you know that you have a buyer that wants those chickens and you're already under contract, and then you're coming to us as the title company and asking for what's showing up in the title, has the ship sailed at that? What do you do? What do you do with a buyer that has a specific concern?
Right.
Because in my opinion, and tell me if I'm wrong, I mean, we're there to test the insurability of the property. But again, I don't know what someone's looking for. So I don't know what's a concern to them and what's not. And by the time I get it, they're under contract. There's nothing in there that says you have to have chickens to be able to go forward.
Exactly, Amy. And that's a good point. So again, it's kind of like there is no out, right? There's no out for your buyer if they simply don't like the CCRs. There's an out if there's an HOA and it's not disclosed, or all of the documentation that's required under the HOA Disclosure Act isn't provided in a timely manner, or in the full documentation that's outlined in the addendum. So again, if you really have someone that's telling you this is a sticking point to me, you may want to have an addendum in there that's written up that says contract is contingent upon buyers, obtaining satisfactory proof that they can maintain livestock on the property, or chickens, or allowed to have 2 horses, whatever the exact thing is. I mean, sometimes it's, something to put in a contract. Yep.
Shelley has a follow-up.
Yes, I do. So in the market that we're in now,
I know.
I don't know that it's realistic. If my client says, I want to have chickens, I mean, if he waits a week, a couple days to go meet with zoning or whoever he has to talk to, that property is going to be gone. So I don't know what a realistic solution would be, because I don't think that would work in this market.
Yeah, I agree. I agree with you. I'm just saying that, there is no real way to give your buyer probably the protection that they want, right? If they have to go under contract, they have to go under contract. And there's just literally, you can see by the paragraphs I pointed out in the contract, there's just no out for the buyer. It is a buyer beware. So your buyer either needs to be prepared to potentially lose the deposit, or maybe factor that into the deposit amount. But, it just can become a sticking point. And again, it's a little bit like Amy said, the ship has sailed once the contract is fully signed for CCRs. And again, timing wise, sometimes, again, it's not on the title company's job to disclose it, because again, we aren't, just like the seller, we have no knowledge of what the buyer's intended use is, or what they might want to do 4 years down the road, or 1 year down the road, or, what their intent is for moving to this particular area. So it really is not very winnable situation for a buyer at this point, certainly in this market, Shirley, as you said. But, that's the only thing that I could, absolutely say would give you some, give your buyer some comfort level. But again, it's not a practical solution. So,
I mean,
anybody else?
Well, Brenda, I was just going to say again, and I know you've said it multiple times already, but just making sure that those buyers really do understand that it is their responsibility, because I have found when there are these outside the private covenant and conditions and restrictions, that when it comes up, every single seller seems to say, well, no one enforces those. They don't matter. I've lived there forever. No one cares. And I've had quite a few experiences where, oh yes, they really did care. And I had one like that. It was a small neighborhood where there was like a 20-acre piece that someone bought that was still bound by them. And the guy wanted to ride four-wheelers and had a big work truck. And the people in that neighborhood came together and said, no way, it's not allowable. And they went through a lot of negotiations, and it ended up where they amended the restrictions to allow for his work truck, and they wouldn't let him drive his four-wheeler. But the seller said all day long for weeks that no one cared, but they cared. So I always take that with a grain of salt when the seller says that.
Yeah, absolutely. Yeah, the bottom line is they are enforceable, and they are enforceable even if just one neighbor decides they get a bugaboo about it, right? If they decide, I'm going to make this my mission, I hate that neighbor, I'm going to make sure that they can't keep their work truck on the property. I mean, they can bring a suit. Anyone. It doesn't require a majority. It just requires one person. Everyone who's supposed to benefit from that declaration has the right to enforce it. Okay. And again, all it takes is the sale to a neighbor who decides, I'm not happy with this, and it's out there. And again, the failure to enforce, just so everyone knows, the failure to enforce a restrictive covenant in the past is never a waiver of the future right to enforce that covenant. Okay, just because you let it slide once or twice doesn't mean you can't enforce it at a later date. That's where they have that language about a waiver is never construed as a termination of our rights to enforce it, whether you like it or not. So,
Raina, that was terrific. It was like drinking from a fire hose. I don't know how you did that without sipping bourbon. You know, and thanks to Amy too for weighing in. We're running on 12 o'clock now.
Yep.
I apologize for the delay at the beginning, but you did a marvelous job, Raina.
Thanks, you guys, and I'm sorry about the delay too, but I think we managed to get it all in, and hopefully you got a little information to take away. And you're welcome, John, to share those attachments and the PowerPoint.
Good. I think Joe has the PowerPoint, right?
Okay.
Good. You guys are great. Thanks for everything.
Thanks,
John.
guys.
Well,
Can I ask a question before you go?
Yes.
Weird situation on my own property. Been here many, many years, had a difficult neighbor. Well, he likes us. I have no clue why, but he fights with everybody else, sues everybody. So he's been using our yard to go into the common area behind us and dumps his leaves and debris for a long time. So he's one of those guys who watches all the legal shows and whatever. So we put a fence up. We found out that he had moved the boundary line, the actual stake, before he moved in many years ago, 2 feet, about to my, I guess the surveyor said. And so all the years we thought this part was ours, it was, I mean, his, it was ours. So he still uses, we allow him to go through our yard, through our fence, our gate, to go back where he used to go. It's annoying as hell, to be honest. But, you know, I just always worry about his state of mind, number one, but having him, if we decided, hey, no more, don't come through our yard, you know, he doesn't have any access to it any other way. So is that something he could actually, I mean, you're talking about.
Probably not, because again, the use is by permission, right? You're granting him permission. I mean, you've seen him, you've erected a fence, you've said you can traverse through this fence area to reach that common area. That is a permissive use. And again, a permissive use doesn't give rise to a hostile, adverse possession issue, right? because it can't be. If I am the owner, if I am the legal owner and I know about it and I'm giving you permission to use it in such a way, that's a permissive issue, okay? And that's probably a permissive personal license to him to let him traverse. It's not something running with the land. He doesn't need it for his land, right? It's not going to benefit his land, right? It's just a personal use, I believe. You know, again, if he's a litigious person, I can't say that he might not sue at some point, but you know, I would doubt that that would be something that would ever rise to a prescriptive easement, because it's not a necessity. He could certainly put his clippings and things out for the trash pickup on
Oh, He
yard.
doesn't have trash pickup because he takes his trash elsewhere to other neighbors' trash cans.
Oh, well, he sounds like a great guy.
Oh, he's great. He's wonderful. So if I put landmines in the area that he walks, would that be a problem?
Talk to your homeowner's insurance.
Chris, it's only going
Yes.
to be a problem once.
Yeah.
That's
Well,
true.
You'll see my face on the news, right? Okay, thank you very much. Appreciate
Thank you,
that.
guys. All right, have a good rest of your day.